Meeting of the Special Committee on Canada-China Relations is called to order. Good morning. Bonjour tout le monde. Bien, bon matin.
Good morning, everyone.
On va entendre
This morning, we're going to have two components to our meeting.
of course, will be on consular affairs, and the second hour is on Canada's extradition process. As colleagues know, tomorrow evening from 5:30 to 7:30 p.m. we'll meet and we'll have Ambassador Barton. And Thursday, the subcommittee will meet from 11 a.m. until noon. Our first witnesses this morning from the Department of Foreign Affairs, Trade and Development are Heather Jeffrey, Assistant Deputy Minister, Consular Security and Emergency Management, and Mr. Brian Schwartz. Is that correct? Senior General Counsel and Director General, International Assistance Group. Good morning. I think you have a 10-minute presentation. Please go ahead.
Thank you very much, Mr. Chair. Members of the Special Committee on Canada-China Relations, I'm very pleased to appear before the committee today to provide a briefing on consular service with a particular focus on the People's Republic of China. My name is Heather Jeffrey. I'm the Assistant Deputy Minister of Consular Security and Emergency Management at Global Affairs, and this is my colleague Brian Schwartz, who is the Director General for Consular Operations. Je commencerai ma présentation ce matin en
I will start my presentation this morning by providing an overview of consular services offered to Canadians. I will then summarize consular relations with China as well as our files and consular trends in that country. And I will conclude by discussing some of our most publicized cases in China.
The Minister of Foreign Affairs is responsible for the provision of consular services to Canadians abroad. These services are delivered by Global Affairs Canada and are guided by the Canadian Consular Services Charter. Les représentants canadiens offrent des services consulaires 24 heures.
We offer Canadian consular services 24 hours a day, 7 days a week, through more than 260 points of service throughout 150 countries, as well as through the Emergency Watch and Response Center in Ottawa.
In order to provide relevant information to Canadians during their travels abroad, Global Affairs Canada makes use of two tools. The department's travel advice and advisories provide information on safe travel to more than 200 destinations, and the registration of Canadians Abroad service enables government officials to contact Canadians in emergency situations. The Canadian Consular Services Charter details the services that Canadian government officials can provide to Canadians abroad. These services include, for example, helping in a medical emergency by providing a list of local doctors and hospital services, providing victims of crime with advice and contact information for local police and medical services, assisting in cases of missing persons or the abduction of a child to another country, and the replacement of passports. In cases of arrest or detention, authorities are obligated by the Vienna Convention on Consular Relations to advise foreign nationals of their right of access to a consular representative. Once Canada is notified of the detention of a Canadian citizen, the first priority of consular officials is to seek immediate access to that person to determine their safety and well-being. In such cases, consular officials would advocate for equal treatment in accordance with local laws, liaise with family and legal representatives, and provide detainees with information on the local judicial and prison systems. Our officials offer consular support to all Canadian citizens, regardless of whether they carry another citizenship. However, many foreign states, such as China, do not recognize dual citizenship and might refuse to allow consular access to individuals they consider to be citizens only of their own country. This is a situation consular officials deal with regularly in the Chinese context. Au total, environ 175,000.
Approximately 175,000 new files were opened throughout our consular network in 2019. The vast majority of these files are routine or administrative in nature, such as passport services or requests for proof of citizenship, and are usually resolved quickly by our missions abroad. However, 6,700 files are more complex. In general, these are cases where Canadians need help to face a difficult situation abroad, such as a death, an arrest, detention, a criminal act, a medical problem, or custody problems. The United States, Mexico, and China are countries that have the highest number of these complex consular cases.
Important to note that protecting the personal information of our consular clients is paramount. Consular officials are obliged to work within the parameters set by the Privacy Act. For this reason, the government is often very limited in what details it can provide publicly regarding specific consular cases. With this overview of consular services offered by the Government of Canada, I will now provide some details specific to our consular services in China. Let me begin by giving a brief update on Canada's response to the novel coronavirus. The current outbreak is of deep concern to Canadians in China as well as in Canada. Actions are being taken to assist the impacted Canadians in Wuhan. As Deputy Minister Morgan informed you last week, Canada has secured a chartered flight to bring Canadians from Wuhan, China to Canada, and we are finalizing arrangements with Chinese authorities to allow this flight to depart as soon as possible. Global Affairs Canada is working closely with the Public Health Agency of Canada to provide relevant and timely travel and health information to Canadians in relation to the outbreak. Our travel advice was updated on January 24th to advise Canadians to avoid all travel to the province of Hubei due to the imposition of heavy travel restrictions in order to limit the spread of the virus. On January 29th, we further updated the advisory to recommend against non-essential travel to China as a whole due to the outbreak. Overall, in 2019 alone, consular officials opened 375 new cases in Greater China. These include cases of arrest and detention, medical assistance, assault, well-being, and whereabouts. There are currently 123 Canadians in custody in Greater China. This figure is inclusive of Canadians in mainland China, Hong Kong, and Taiwan. I want to stress that the number of Canadians in custody in China has remained stable over the last year. The provision of consular services to Canadians in China is governed by a bilateral agreement signed by Canada and China over 20 years ago. This agreement, which is available publicly, details the consular obligations and entitlements of our two countries in order to facilitate the protection of the rights and interests of our citizens. Je vais maintenant vous faire un résumé de cette.
I will now summarize some of the most publicized cases regarding China, those which, in my opinion, represent a particular interest for the committee. Given the public nature of this meeting, I am limited by the provisions of the Privacy Act when it comes to the personal information that I may share. The Government of Canada is extremely concerned by the cases of Canadians who are arbitrarily detained or who are likely to face the death penalty in China. Canadian representatives at every level have raised these concerns with their Chinese counterparts, and they continue to do so.
Canada opposes the use of the death penalty in all cases, everywhere. Aligned with this principle, the Government of Canada seeks clemency for all Canadians facing the death penalty. Canada has raised with China our firm position on the death penalty, and we have called on China to grant clemency to Canadians facing this sentence. In the cases of Michael Kovrig and Michael Spavor, the Government of Canada has been unwavering in its position and in calling for their immediate release and return to Canada. As you will no doubt be aware, Mr. Kovrig and Mr. Spavor were detained by Chinese authorities on December 10, 2018, accused of posing a threat to China's national security. They were formally arrested on May 6, 2019. Officials at the Embassy of Canada to China have had regular consular access to Mr. Kovrig and Mr. Spavor since their detention in December 2018, conducting consular visits on an approximate monthly basis. The latest consular visit to Mr. Spavor took place on January 13th and to Mr. Kovrig on January 14th, led by Ambassador Barton. The Government of Canada has been very clear that these two Canadians have been unacceptably and arbitrarily detained. We will continue to call for their immediate release. Mr. Robert Schellenberg was detained by Chinese authorities in 2014 and charged with drug smuggling. He was initially sentenced to 15 years of imprisonment, but at a December 2018 appeal hearing, a Chinese court ordered a retrial. The next month, a judge overturned the initial verdict and issued a death sentence. Mr. Schellenberg has appealed the death sentence, and a hearing took place in May 2019. The verdict is pending. Canada has strongly condemned the sentence of death imposed on Mr. Schellenberg at his retrial, and we expressed our extreme concern that China chose to arbitrarily apply the death penalty in his case. We have called on China to grant clemency to Mr. Schellenberg. The particular cases that I've highlighted today represent only a few cases of the Canadian citizens in custody in China. While privacy details will limit me from providing any details on specific cases, I want to stress that Canadian officials, both here and in China, are actively engaged on all of these cases and will continue to raise concerns with Chinese authorities. Thank you for the opportunity to present this consular overview to the committee, and we look forward to your questions. Thank you.
Thank you very much. And now we'll begin with the first round of questioning. We have Mr. Jennis.
Thank you, Mr. Chair. Thank you to the witnesses, and it's a pleasure to be here at this important committee. Maybe I'll start. It's been in the news recently, the case of a woman who's a permanent resident who's in Wuhan, and I wonder if you could speak to the approach you take with permanent residents around provision of consular services, and maybe walk out a little bit the decision not to include in the evacuation those who are permanent residents of Canada.
The situation in Wuhan was first raised about a week ago, just over a week ago, with the imposition of quite severe quarantine restrictions on a large province. The Chinese government imposed these measures in an effort to stop the spread of the coronavirus. With the imposition of those measures, Canadians and permanent residents in the province found themselves unable to depart. Commercial means of transportation were blocked. And since that time, we have been working 24/7 to reach out to those Canadians and to find ways to assist them. And the Minister Champagne spoke yesterday about the measures being taken in terms of the evacuation flight. In cases of humanitarian nature, such as those that we see in Wuhan, our policy is to provide full services to all Canadians and permanent residents and their family to the extent that we are able. However, the policy of the government of China is that our consular access and services is restricted in practice to Canadian citizens, and in many cases to Canadian citizens who entered China on a Canadian passport or travel document. We've been working with the Chinese government to find a way to facilitate the exit of those Canadians on our evacuation flights. We've obtained the agreement of the Chinese government to allow permanent residents to accompany Canadian citizen children that need to evacuate that zone, which is some progress. We are continuing to advocate for others, but in the end analysis, it will be the decision of the government of China whether they allow that. But on our side, for the person of the government of Canada, we are doing our best to offer those services to Canadians.
Okay, so just to be very clear, because there's a story in the Toronto Sun about a particular case, a woman named Debbie Liu. So what you're saying is the Canadian government is prepared to allow to support the evacuation of her and other people in that situation, that is permanent residents without children, if the Chinese government allows it.
We're engaged in discussions with the government of China about what restrictions they're placing on the evacuation operations. Okay. I'm not in a position to comment about where those discussions will end, but we are making some progress, and we will continue to work on this.
Okay, thank you. In a different vein, in the context of the two Michaels, as they're often called, there have been a lot of political commentary by prominent people connected with the governing party, making suggestions like for instance, a prisoner exchange was what one former minister had suggested as a way to resolve this. Could you comment from your perspective on the appropriateness of that kind of a suggestion?
So from the perspective of the Privacy Act, in order to protect the individual in question, it would not be advisable for us to comment on the strategies for any particular case. What I will say is we are working very intensively for the safe return of Michael Kovrig and Michael Spavor, and for the clemency of Mr. Schellenberg. We do that by assessing the variety of approaches we can make, the different channels we consult, and in this case, where these cases are so evidently intertwined with broader bilateral considerations, we work across government and with other partners to pursue every possible avenue. That includes private and public advocacy. It includes bilateral engagement directly, and it can also include joint approaches with other countries.
Right. Sorry. Can I just dig into that point, though? I mean, take it away from the particulars then and make it a hypothetical. Like, would you ever think that a quote-unquote prisoner exchange of somebody lawfully detained in Canada for somebody arbitrarily detained in another country, would you ever recommend that as sort of a good approach for trying to resolve a consular case or not?
In terms of the consular services we can provide to people that are arbitrarily detained, and we call this case an arbitrary detention because of the timing of it, because of the decision to order Mr. Schellenberg's retrial, because of the public comments that were made by China's Prosecutor General in terms of the circumstances of the detention. We are using every avenue available through our consular services to advocate for their well-being, to provide consular services directly through our visits, and also to develop the consular plans and strategies that inform the whole of government approach.
Yeah, I completely agree with you in the characterization of these as people being arbitrarily detained. Is it fair to say that comments that suggest that Canada should be releasing a person who is legally arrested by independent law enforcement agencies, is it fair to say that comments by politically well-connected people along those lines are very unhelpful to Canada in trying to actually make the case that these are arbitrary detentions in China?
I'm not going to speak to the views of others, Mr. Chair. I can only speak to the consular approach that we're taking on the ground, and I can assure you that we're working very intensively through channels at all levels of government.
Thank you. Can I just ask if quickly the Chilil case? I don't think you might. Can you give us an update at all on the Chilil case and what action the government of Canada is taking around that case?
Very, very briefly.
Thank you.
So the government of Canada is deeply concerned by the credible reports of detention and family separation of Uyghurs in China, which run counter to China's human rights obligations. We've urged the Chinese authorities to release those that are detained. In the case of Mr. Chilil, we have not been granted consular access to him, but we continue to advocate and to call on Chinese authorities to do so.
Thank you, Mr. Jennis. Mr. Oliphant.
Thank you, Mr. Chair. And I start by offering huge thanks from members of the Liberal Caucus for your work. 2020 has been, I think, one of the most taxing years that I have seen with respect to consular services, with the downing of Ukrainian Airlines Flight 752, which was hugely taxing for your small department, to be immediately followed by the coronavirus crisis. So thank you for what you do and for coming. I thought you might have good excuses to not be here today. You raised the issue. We have thousands of consular cases every year. We have hundreds of difficult ones and 100 or so very complex cases. That work is ongoing. In the midst of this, the coronavirus has required that you be nimble. I'm just wondering how you started with the coronavirus plans. There has been a criticism that we didn't have a plan from the government side, and I have seen some of those plans. We're just wondering what kind of a planning process you start with when you're facing early signs of a health issue like a pandemic like coronavirus.
Yes, Mr. Chair, we began with reporting through our Emergency Watch and Response Center, which is actually an emergency management and a tool that sort of conducts a bit of a watch, what's happening globally around the world. We have situation reporting to inform people of developing situations. And in the case of the coronavirus, we began in January to track the spread of that virus. On the 26th of January, we stood up an emergency response team when we saw the measures being taken by the government of China to control the spread of that virus and the challenges that was putting in place for local residents in Hubei province in particular. I would say at the time, the full extent of the Canadian presence in Hubei province was not immediately evident. We don't have a consulate in that province. And at the time, there were only a very small number of Canadians that were actually registered through the Registry of Canadians Abroad as being resident in Hubei. I would say generally when Canadians feel in a more secure or safe place, they tend not to think about registering with the government when they travel. They do so, I think, in more what they perceive as more dangerous or hostile areas. But in this case, we only had, I think there were only about 38 Canadians registered. Now we know that there are many more. We're up to 565 Canadians registered in Hubei province. About 8 or 9 days ago, we had no requests for consular assistance. Those requests have obviously escalated. Currently, all the requests we have in Hubei are from Canadians seeking assistance to depart. We have no cases of Canadians who are ill with the virus that are looking for our help to leave the province. And we've been working with the government of China to obtain those permissions. Obviously, a response and an evacuation out of a quarantine zone in a country such as China poses some unique challenges. Every emergency response is different, and this one indeed has a lot of complexity to it. The process, we immediately put in place a process to put together the evacuation flight and seek the necessary permissions. We required visas from the Chinese government. We required overflight clearances from a number of countries, some of which have closed their airspace in recent days. All of those challenges have been met and overcome, and we are now not that far away from removing the first tranche of Canadians from that situation. But it does require a very detailed response. We had to send a ground team into Wuhan, so we now have a consular team on the ground in Wuhan City. They're preparing the logistics for the departure. We've been working with local authorities, completing the manifest of passengers, and also compiling all of the details that are required to do ground movements in an area under such severe quarantine restrictions. People have to inform us of their routings about how they're going to get to the airport.
Can I ask you how you have found? I mean, obviously we have a frayed relationship right now with China, and it has been difficult for over a year. In this instance, have you found this to be a normal exchange that you would expect with Chinese officials, cooperative or not cooperative? Are they seeking our assistance? Are we seeking their assistance? Is it a normalized? It's an abnormal situation, but is this within the range of what you would expect for Canada-China cooperation?
To say in terms of the discussions that we've had with Chinese authorities in regard to the evacuation plans, these discussions have been constructive. We have been working. They have issued visas for our team, and we are working through the details of some of the complex family situations that have been raised. And we're continuing to have those dialogues, and they've been responsive to our requests today.
Thank you. Thank you, Mr. Chair.
Oui, merci, Monsieur.
Yes, thank you, Mr. Chair, and thank you to our witnesses for their presence here with us today, especially in this context, which is certainly a busy time. Do members have an exclusive telephone line to discuss consular cases with Global Affairs?
So in the cases of members of parliament, we do work directly in some cases when families provide consent for members of parliament to act on their behalf. We'll engage to the extent that families allow us.
Oui, mais est-ce qu'il existe une ligne?
But is there a direct line for members, or do we just call Global Affairs in general?
If I may answer that, please. There is a process by which members can direct their inquiries to the office of the minister. They can, on behalf of their constituents, they can raise those issues. And we have a very well-working process for those requests to be directed
Donc,
to.
on passe par le cabinet.
So we go through the minister's office.
Deuxième.
Second question. In light of the consular cases that you brought to our attention, would you say that China violated the consular agreement between the government of Canada and the People's Republic of China?
Agreement that we have bilaterally between Canada and China, as I mentioned, is 20 years old. It was put in place to establish a minimum threshold for access, in particular cases of dual nationality, where prior to that there had been extreme challenges. It lays out what I'd say we consider to be the minimum standards, and we're always advocating to go beyond them.
Mais quand vous nous...
But when you tell us that you were refused consular access to a Canadian citizen, is that not a violation of that agreement between the two countries?
Under the agreement, China has only agreed to provide us access to those Canadian citizens who entered China on a Canadian travel document. So if you are a dual national of China and entered on a Chinese document, under the agreement, China has said they will not provide us access.
Et est-ce que cette disposition était prévue?
Were these measures included in the agreement between the two countries, the possibility of people with dual citizenship?
The Government of Canada is that all Canadian citizens have the right to consular access under the Vienna Convention, and we continue to advocate for that at every opportunity. There are many countries in the world that do not accept that position, and we continue to advocate despite
Mais plus
that.
spécifiquement, est-ce que
More specifically, were these measures included in the agreement between both countries?
Agreement was signed to respond to the fact, in part, that the government of China was refusing to recognize consular access for any dual national Canadians in China. It allowed us to make some progress in terms of accessing dual national Canadian Chinese citizens who entered China on Canadian travel documents. We would obviously prefer, and we continue to advocate as a position of the Government of Canada, that we should have access to all Canadians.
OK. Alors,
In a general sense, how many consular visits were done for Mr. Kovrig and Spaver? And on average, what was the length of those visits? What kind of environment or conditions would you say that those visits were conducted? And were you able to determine anything about the conditions of detention of those two Canadians?
Well, as I'm sure the committee can appreciate, behind every one of these consular cases is the personal situation of Canadians in distress. To protect their privacy and to protect the privacy of their families. We're not going to comment on the specific details of their conditions or their cases. We do continue to visit them, and we have had monthly access to both Mr. Kovrig and Mr. Spavor. But unfortunately, for reasons of the Privacy Act and to protect the families and those individuals and the progression of their cases, I'm not going to comment on their personal situations.
OK.
Very well. Would you say that you have an adequate access?
That we are continuing to advocate for greater consular access to Mr. Kovrig and Mr. Spavor, and for their access to their families and to additional supports. We advocate for their well-being with local authorities, and we are continuing to find every possible way to support them in what are very difficult circumstances.
OK.
Okay. A simple question. If members of this committee were to eventually decide to travel to China, do you see any consular issues for members of this committee? And would you see value added in terms of the conclusions that the committee work could draw when it comes to directly observing the relationship between Canada and China?
The advice that we offer to all Canadians is our travel advice for China. At the current time, our travel advice is at a level 3, which is to avoid all non-essential travel to
Éventuellement, plus tard.
China.
Eventually, later.
And I'm sure we would be happy to engage with the committee in terms of the travel advice in the moment that you're considering. In terms of the work of the committee and its mandate, I will respectfully leave that up to the chair and its membership. But we remain at your service to answer questions and to support your work.
Avez-vous demandé la question des visas?
What about the issue of visas? Did you ask a question about visas?
Simplement,
I just wanted to know if it was requested. This might be worthwhile for members of the committee. Would it be difficult to obtain them or not? I think that that's a very interesting complementary question, Mr. Chair.
for a second, I'm sorry. interrupt.
I can't comment on a hypothetical
Fair
question.
enough.
We would
Okay.
have to.
All right. Thank you. Mr. Harris.
Thank you. Thank you, Chair, and thank you to the witness for coming. I did have one question at the beginning. I asked you about it earlier, that you're listed as the ADM of the Department of Foreign Affairs, Trade and Development, and we keep hearing about Global Affairs Canada. I'm assuming they're one and the same thing. One may be more of a brand. And could you explain the difference?
I believe that the continuing legal name of the department is the Department of Foreign Affairs, International Trade and Development, but the working name that we use is Global Affairs Canada. So they're both correct.
Thank you. I think that might help some people on the committee and in the general public to know the difference. Thank you for that. I just wanted to follow up briefly, but I have some other questions on Mr. Genesis's question about the bringing permanent residents back to Canada. I didn't get a confirmation from you that Canada would be happy to bring permanent residents back to Canada as part of this evacuation, as long as there's consent from the Chinese government. Is that correct?
So in terms of the provision of consular services brought under the Vienna Convention, that provision of consular services is focused on Canadian citizens in the first instance. However, in cases of natural disaster, humanitarian responses, evacuations, such as what we see in Hubei, we try to preserve family unity, to extend services to those Canadian citizens and permanent residents that we are able to. That has been the case, for example, in responses to previous hurricanes and other emergency responses. In the case of the particular situation in Hubei province, the government of China has made clear that its position is initially that foreign nationals who are traveling on their foreign national travel documents would be facilitated to exit, and we have managed to work with the Chinese government.
Excuse me, I don't mean to interrupt. I understand that. My question is, and Mr. Dennis was speaking about a person who wasn't accompanying Canadian citizen children, but who was a permanent resident of Canada. Would the Canadian government assist in the evacuation of such a person, assuming the Chinese government approved?
We've been working with all Canadians and permanent residents on the ground. We've been exchanging with them to determine their needs, and at the moment it is a hypothetical question. We're working with the government of China to see what is possible and how we can assist everyone who's on the ground there seeking to depart. We recognize fully it's an extremely difficult situation to be confined and to not have an opportunity for departure.
No, I appreciate that. I don't want to waste my whole time on this question. I thought it was a yes or no question. Obviously, it's not a yes or no question. There are people who want to come back who are permanent residents but are not being accompanied by children, and the answer is qualified. I understand it. Can I ask about the agreement with the bilateral agreement with China, with the Vienna Convention? Is China in compliance with the Vienna Convention? Was the 1999 agreement to add additional safeguards, or was it to try and get them to agree to abide by the Vienna Convention?
What I would say is that the Vienna Convention, obviously written many years ago before the prevalence of dual nationality, it doesn't contemplate specifics in regard to many of the modern day challenges that we face in terms of the provision of consular services. And it's for this reason that we've been trying to work bilaterally with different countries to try and enforce the access that we need to serve Canadians abroad. So it was in that vein. So the Vienna Convention provides a lot of different protections, both diplomatically and in terms of consular officials, and but we are looking for more specific undertakings from governments in order to allow us to do our work.
So you're suggesting that the bilateral agreement is inadequate for these circumstances?
I'm suggesting that we're continuing to advocate for greater consular access to Canadians than the Chinese government is providing us with.
Well, I think that does answer the question. Thank you. We're advised that the current travel advisory for China indicates that Canadians should exercise a high degree of caution in China due to the risk of arbitrary enforcement of local laws. And this is a notes provided to us as of January 24th. Is that a new designation, and how long has that been in effect?
So the current travel advice, as I mentioned, is actually that Canadians should avoid non-essential travel to China because of the coronavirus and the measures taken to prevent its spread. Last January, we did update the advice to highlight the risks of arbitrary detention. There is a great deal of detailed information in the travel advice about the different areas against which we caution Canadians and some of the things that they would need to consider. The decision to travel or not to a particular country is the decision of an individual Canadian, and our efforts are to provide them with the information they need about what we have observed and some of the challenges that Canadians have experienced, and also information on local context so that they can take the best informed decision possible.
Always good advice to be careful, but my question is that something that is new as a result of the developments with Michael Korvik and Michael Spavor, or is that something that advice that you've always given? Is that a concern always in China, or is this a new concern that's being highlighted for a particular reason?
So the level of the advice was at exercise a higher degree of caution prior to that, and we have brought up the level of that particular risk to the top of the advisory to draw the attention of Canadians to it.
Do you have a list? You mentioned the word list. Are there a number of Canadians who are, in the view of Consular Affairs of Canada, who, in addition to the two that are top of mind, that are considered to be arbitrarily detained in China?
Arbitrary detentions take place in different countries across the world, but in relation to the government of China, the two cases of arbitrary detention that we have highlighted are the two cases of Michael Kovrig and Michael Spavor, and also the sentencing of Mr. Schellenberg to the death penalty.
Thank you, Mr. Chair. It's great to see you both, my former colleagues. I was remarking to Brian, I was actually his assignment officer when he was in Mongolia, so I can't believe we've come full circle here. Of course, coming from the position of a former diplomat, my strong core belief is that diplomats only do what their government asks them to do. And so my questioning is really always to see where you receive your direction from working for the government and working for your political masters. So with that, I'll start with where are Kovrig and Spavor currently detained in China?
I'm sorry, but as I explained earlier, due to the Privacy Act, I'm not going to comment on the particular circumstances of the cases.
Okay, so then we'll assume that they are detained in Beijing for the sake of this. So you mentioned that there is the consular agreement between Canada and China, beyond the provisions outlined in the Vienna Convention. Would we be able to table that document here within the committee?
So the consular agreement?
Yes.
It's available publicly. It's on our website.
Super. Has there been a contiguous consul in Beijing since the time of their detention?
We have always had a mission in Beijing. We have had a chargé d'affaires, an ambassador, a head of consular section.
Okay, but has there been one consul since their detention?
In terms of the consular officer?
Correct,
in particular?
like one consul.
We have a consular team.
If we could get the name of the consul since their detention, or if there's been more than one, the names of those, and have those brought to the committee, that would very much be appreciated. Who was the head of mission at the time of their detention?
At the time of their detention, it was our previous Ambassador McCollum.
Okay. And who did the head of mission report to in Ottawa regarding these two cases?
Heads of mission are appointed by the Prime Minister. And
okay, who did they report to in Ottawa? Did they report to the geographic officer, or did they report to a more senior officer than the desk officer?
I'd like to explain that the consular strategy that we applied cases is developed by the consular team in consultation with our colleagues, and we develop those strategies and consult them across the government. Okay,
I think it would be helpful if we could find out here in the committee who the head of mission reported to in Ottawa at the time of the detention of these two cases and throughout these two cases. Who was the deputy head of mission at the time of the detention of Kovrig and Spavor?
Our deputy head of mission is Mr. Jim Nicol.
Okay, and was he the deputy head of mission at the time of the detention?
Yes.
Okay, excellent. Which officers were assigned to Kovrig and Spavor during this time?
I'm happy to I don't have all the details of the staffing of the embassy, and we're happy to work with the clerk and the chair of the committee to provide that information.
Okay, that's great. Now, I understand the privacy information which you provided previously, but I recall during my time in the Operations Center from 2004-2005, my colleagues specifically working on the case of Omar Khadr in an attempt to provide that information, certainly with the redaction as necessary. So with that, I would ask, would it be possible for the committee to have all Cayman notes tabled from the two cases, please?
The Privacy Act governs what we're able to release publicly, and we'll work with the clerk of the committee to respond to whatever requests are made.
Okay, well, I've asked for a lot here in terms of names and information, but if we could certainly receive this by, I'd say, 2 weeks from today, Mr. President, whatever that date is, I would genuinely appreciate it. Now I'll move to the greater consular issue, of course, at this time, which is coronavirus. So I would like to know, why has our response lagged behind other nations so significantly?
I'd say that we've responded very quickly to the outbreak. We've been tracking it since it began, and we've been tracking as well the needs of Canadians as they developed.
Yeah.
As I mentioned earlier, we don't have a consular presence on the ground.
Where
in
does
Hubei
Hubei province report to? Which consulate, please?
The witness was just talking about, I think the consular presence are on the ground in Wuhan, but I'd like to hear the answer. If you
Okay.
don't mind hearing the answer, and then go on. You've just heard the question. Ms.
Thank you,
Lucy
Mr.
has asked.
President.
As I mentioned, we do not have a consular presence in Wuhan. The area of Wuhan is under the governance of our consulate in Shanghai. And we're providing consular services through the consular section there. As reports came in that Canadians might be having difficulty in leaving the area, we tracked those, we engaged with those Canadians. But actually, it was not until at the beginning of last week, midway through the week, that it became apparent that there was a systemic problem with a very large number of Canadians that were going to need assistance, and we immediately took action to engage options, to charter a plane.
Perfect. Thank you. If we could get the consular plan from Shanghai tabled for the committee, that would be excellent as well. And finally, who is currently leading the Standing Rapid Deployment Team out of GAC, please?
The rapid deployment teams are under my management at the Department of Foreign Affairs at Global Affairs Canada. They are trained and dispatched through the Emergency Watch and Response Center.
And if we could get the plan tabled, that would be great from the rapid deployment team.
Sorry,
Thank you very much, Ms. Jeffrey. Thank you, Mr.
I was
Sarkis.
getting around to the 5-minute round, and I was thinking 6 minutes. So forgive me for that. And I do want to make sure that perhaps the witnesses have appeared before committees before, but I just want them to understand that when members have only a short time, sometimes they will be anxious to get as many questions as they can. I've certainly experienced that myself on committee in the past. I think the next 5 minutes are going to be shared between Ms. Zan and Ms. Yip, I believe. Ms. Zan, please.
Actually, I think Ms. Yip is going to go
Excuse
first.
me. Thank you.
Thank you for coming, and I really have to commend the hard work you and your team have done with the downing of the Flight 752 and the recent coronavirus. Have Chinese authorities presented any evidence regarding the national security charges against Mr. Korvig and Mr. Spavor?
I'm not going to comment on the details of the cases, but those cases are still under investigation by the Chinese authorities, according to what we've been told.
Well, I'm going to give this another try. When are Mr. Korvig and Mr. Spavor expected to be tried? And when they are tried, will they have access to effective legal representation?
The timeline for trial and sentencing is very flexible, and there are many opportunities generically in the Chinese system for extensions and adjustments, so it wouldn't be appropriate for me to speculate on timing in any specific case.
Are they receiving any legal advice now from the consular officials?
Again, I'm sorry, these are all details of their personal situation. I'm sure, as I mentioned, the committee can appreciate that these are very difficult situations for Mr. Korvig and Mr. Spavor and their families. They've asked for privacy, and under the Privacy Act, we're obliged as consular officials to respect that. So with respect, unfortunately, I can't answer your question. I'm sorry.
Okay, thank you. With respect to Robert Schellenberg, have Canadian consular officials have access to him since the ruling that he be put on death penalty?
Yes, we have been provided consular access to Mr. Schellenberg, and we visit him.
How many Canadians are on the death row?
Due to the Privacy Act, I'm not going to comment on the cases of specific Canadians and their sentencing.
Okay. Would you like your time now? Okay.
Thank you very much, Mr. President.
Monsieur Bergeron, un appel au règlement.
Oui,
Mr. Bergeron has a point of order. I understand the concerns of our officials when it comes to the details of the consular cases that are currently being dealt with, but this is a general question. We just want to know how many Canadians were facing a death sentence. We just need a number. We don't need details. It seems to me that this is information that could be communicated to us, Mr. Chair. Thank you, Mr. Bergeron. I understand that the witnesses want to make sure they're in accordance with the law. It's clear that the members of the committee would like to have the most information and details possible.
Well, I can't speak to the details of the cases. There are two Canadians. There's Mr. Schellenberg and Mr. Fanway, whose charges on the death penalty are public and available.
Thank you very much. Ms. Zan.
Thank you. Merci, Monsieur le Président. Thank you for being here. And again, thank you so much for your hard work on behalf of Canadians. As has been said, we know you're under a lot of stress. And the situation, I'm sure, does keep changing, and you have to become pretty nimble to deal with it. I would like to know a little bit more about the situation on the ground with regards to the coronavirus and the Canadians who are still in China. I believe they are being quarantined right now, everybody who is there. Is that correct? And also, what are you telling Canadians there to do to protect themselves for their health?
Thank you. So the government of China has taken different measures in different areas to respond to the spread of the coronavirus in an effort to impede its continued extension. Hubei province is the focus of attention because of the particular restrictions around travel in and out of that province. It was, for example, required special permissions for our consular team to enter Hubei province. It is closed to traffic. And Canadians in Hubei province have been telling us in their conversations with us that they have been instructed to stay in their homes, to avoid gatherings. Many of these types of measures to impede the spread of virus actually would align with in terms of avoiding large groups and these kinds of things with the advice that we take, which is given by the Public Health Agency of Canada as the expert body in Canada that advises us. And we have been consulting with them, and they provided advice to us in terms of how to protect not only our staff, but also Canadians on the ground. The measures are the same that they have spoken about here in Canada: frequent washing of hands, avoiding contact, these kinds of things, self-isolation, and we've also provided advice on what to do if you have symptoms to avoid exposing others. They've also advised us on the types of protective kit that we should be using for our flights. We have very detailed medical advice on how those flights will take place, and we will have a D&D medical team on board the aircraft to provide medical assistance to Canadians who might need it in flight. In terms of the evacuation, I would just underline that the government of China will be conducting medical checks. Given the nature and the reasoning behind the quarantine, they have informed us that no one who is symptomatic will be allowed to depart Hubei province. They will be conducting medical checks on entry to the airport, inside the airport, and we will also be conducting, through D&D medical personnel, checks before Canadians board the aircraft to ensure everyone's safety and security.
Thank you, Ms. Zan. As I go to Mr. Albus, I hope he won't mind me suggesting that members of Parliament probably should wash hands more than most, because I can't think of any other group that every weekend goes off to every part of the country, shakes lots of hands, comes back to Ottawa and shakes lots of hands. Mr. Albus.
Wow. Thank you, Mr. Speaker, or Mr. Chair. Thank you for the work you do. Obviously, a lot of resources are given to your department, so like all of us, when you give someone resources, you expect people to use them wisely. I just would like to make a quick statement, especially for new members of Parliament, that the embassies and consulates, when members of Parliament could no longer contact them directly on behalf of their constituents for routine matters, that occurred right after the Liberals took office in 2015. And I have to say, from my own experience as a constituency worker, that has complicated, and it also insulates those consulates from the general public, as does, I believe, the Privacy Act. I believe it gives too much insulation for the government. And so I would like to see a little more transparency from your department when it comes to these things, because ultimately all of our salaries are paid for by the public, and we shouldn't take a crisis for people to start getting basic information specifically. So I'm going to be focusing largely on those matters today, Mr. Chair. So there are no publicly available statistics on the numbers of Canadians in China and the number of consular cases. So if you could start by saying how many Canadians are currently in mainland China and in Hong Kong, and how do those figures compare to previous years?
So, Mr. Chair, I can respond to that in part, which is that the Government of Canada does not track inside China the presence of Canadians. We don't track the travel of Canadians. So this is an area where our figures, not just for China, but for the rest of the world, are not complete. We don't have a firm estimate about how many Canadians might be in China at any given point in time.
So again, from a public interest standpoint, this insulates the government because we don't know effectively if the government is resourcing our consulates in the correct regions that face the biggest challenges. So I would just simply say that a little more transparency needs to happen there. Now, let's go to things that you can talk about. How many Canadian consular cases are active in China right now?
We currently have in China, in 2019, there were 375 new consular cases.
Okay, how many were routine or administrative in nature? How many would be more considered complex?
Okay, so overall, if I look at the overall number of cases, the way we track them, there are 26,500 cases in 2019 in China. 4,500 of those were citizenship requests, 20,000 of them were passport related, and there were 375 what we term consular cases that are more complex. Of those, 123 were cases of detention, and these are figures I would say for Greater China, so that includes Hong Kong and Taiwan. The arrest and detention cases are primarily related to drug-related crimes and to fraud. We had 135 cases of deaths abroad, 48 requests for well-being and whereabouts, people looking for their family members, and 36 requests for medical assistance, and 12 family-related children cases.
Now, obviously, there's a fair bit of concern for Canadians that are detained abroad. Can you give us, particularly in China, can you give us an example, or can you give us just a total number? Again, I do believe Mr. Bergeron asked a good question. I do think we should have a general number of how many Canadians are detained.
Globally?
In China.
In China? Currently, we have 123 Canadians who are detained in Greater China, so that includes China, Hong Kong, and Taiwan.
How many have happened in the past year?
Sorry, I'll have to...
Would you mind maybe tabling it for the past few years, just so that we can understand that better, just to see if there's an uptick? I think it's important to know. For those Canadians, how are they able to access needed consular service? You explained a little bit before that if anyone asks, then you have a duty to it. Now, that's not legislated, is it?
Consular assistance in Canada is granted under the Royal Prerogative, and our consular policy is to offer consular service to all Canadians under the Consular Charter. We are typically notified by host governments of detention cases, and if we are notified of them from other sources, we will proactively contact detention centers, local authorities, and reach out. Not in all cases, in all jurisdictions, are local authorities as assiduous in informing us as we would like, so we use all possible means. People don't have to reach out to us. We're actively looking for them in most cases.
Thank you.
Mr. Dubois.
It is now my turn to thank you for being here with us. I would like to come back to the cases of the two Michaels, Michael Kovrig and Michael Spavor. I hope you can answer this question. You said that consular representatives were allowed to visit once a month, to visit these two prisoners once a month. Since their arrest, if the law permits you to tell us, have the parents of these two people have been able to contact them via telephone or visit them?
Due to the Privacy Act and the wishes of the families, I'm not going to comment on the particular circumstances of their case and their interactions. I'm sorry.
OK, merci. D'autres questions? Vous venez de dire à mon collègue.
Thank you. Another question. You just told my colleague that 123 Canadians are currently detained. whether it be in China or Hong Kong. We know that last year there were protests, very acrimonious protests in Hong Kong. Are there Canadians who were arrested during those protests? And if so, how many?
We did have reports of a number of Canadians who were detained related to those demonstrations. However, to my knowledge, all have currently been released, and we have no Canadians currently detained.
OK, d'accord. Et
Very well. One last question. I know that I don't have a great deal of time. When the risk level is raised for a country, like as is the case for China now, are you consulted? How does it work?
Deciding to raise the level of the travel advice, we take input from a wide variety of sources. We look at the local circumstances on the ground, the reports of the mission, the consular caseload, trends that we see. We also consult with other partners who have different information on what's happening in the region, and we use the criteria for the different levels to apply the levels of risk. It's evaluated on a 24/7 basis. Updates are made throughout the night. For example, in cases of natural disaster or sudden emergencies, it's very important that Canadians have that information as quickly as possible. So we are continually reviewing the travel advice for all countries, and we look at specific regions within the country so that we can target advice in areas of a country that might be, for example, of a higher level of risk than others.
d'accord, une question.
One question.
Coronavirus présent.
When it comes to the coronavirus right now, we know that there are Canadians who are going to be quickly repatriated. There's a second plane that it would seem that is being arranged. If Canadians are in China but not in Wuhan, will those individuals be repatriated as well if they communicate with consular officials? Will they be part of the next departures?
Policy is to target our assistance to the needs of Canadians. In cases where there are commercial options to depart a particular area, that is the most expedient and easiest way to depart. Our evacuation support is restricted only to those cases where Canadians really have no other options for leaving a particular area. So each circumstance is different. In the case of Wuhan, obviously, we have a large concentration of Canadians who have made their needs known, and we're responding to those. And there continues to be regular commercial traffic to and from the rest of China, and we will be monitoring the needs of Canadians as the situation progresses.
Thank you.
Jip, the last minute.
With respect to the coronavirus, is there adequate counselor staff and planning to support the number of Canadians in the affected areas as well as the non-affected areas elsewhere in China?
Yes, so you will have seen earlier this week that non-essential staff were drawn down from some of the missions in our China network. However, for us, essential service and the primary essential service in this context in China is consular services to Canadians. And we are actually increasing our consular staff and consular support in the China network. And full services remain available. We have a call center staffed with over 50 people receiving calls on a 24/7 basis, and our emergency watch and response center has been working shifts since the beginning of this crisis, fully staffed to respond to needs. Calls come into the response center, and we triage them so that our missions on the ground can respond to the most sensitive and difficult cases. And we respond to requests for information through the call center so that everyone can have consistent and timely information. So it's a network that we're using to support, and it isn't just within China. It's also through our standing rapid deployment team, which is increasing the number of consular officers in China. We've also deployed on the ground to Wuhan. So actually our consular support is much more extensive than it was before this outbreak.
Ms. Jeffrey, Mr. Schwark, thank you so much for appearing this morning. We will now suspend and allow the witnesses to depart and the next set of witnesses to take their places. Thank you so much. The meeting is suspended. come to order. For our second hour, we have witnesses from the Department of Justice. I believe it's to talk about extradition. We have Mr. Owen Rees, Deputy Assistant Deputy Attorney General, and Ms. Janet Henchy, Senior General Counsel and Director General, International Assistance Group. Order, please.
Mr. Chair, Mr. Chair, could I ask the members on a point of order to actually take their seats so we could hear the testimony? Thank you.
Thank you. I think members are now taking their seats. So we'll ask the witnesses to begin their 10-minute presentation.
Thank you, Mr. Chair. Good morning. Thank you for your invitation to provide a technical briefing to the committee on the extradition framework in Canada. My colleague, Ms. Henchy, is Senior General Counsel and Director General of the Criminal Law Operations Section. Ms. Henchy and her colleagues at the International Assistance Group are responsible for the administration of the Extradition Act and the Mutual Legal Assistance in Criminal Matters Act on behalf of the Minister of Justice. The IAG reports to the Assistant Deputy Attorney General, National Litigation Sector, whom I support. The National Litigation Sector is responsible for the conduct of litigation involving the Government of Canada or any department. You'll see that we've distributed a deck which may assist you in following our presentation this morning. Extradition is the process.
Just one moment, Mr. Chair. Do we have that deck?
I think members may find it in the folder that's in front of them. I see you have it, Mr. Alford. Okay.
Sorry.
Thank you very much. Carry on, please.
Thank
Try
you.
not to have any further interruptions.
Extradition is the process by which an accused or convicted person located in one country is surrendered to another country pursuant to a request by an extradition partner to face trial or the imposition or enforcement of a sentence. Extradition is an important tool of international cooperation used by Canadian and foreign police and prosecutors to fight serious crime at a global level. The Minister of Justice is responsible for the administration of the Extradition Act and the implementation of Canada's extradition agreements and for the dealing with requests for extradition to and from Canada. At the surrender stage, the Minister must personally determine whether to order the person surrendered to the requesting state. The Minister's authority under the Extradition Act is otherwise in large part delegated to legal counsel in the International Assistance Group, or IAG, a group within the Department of Justice. The IAG receives the requests for extradition and the requests for provisional arrest warrants, which are used in urgent circumstances to arrest a person before the extradition request is received. The IAG determines whether to seek with a provisional arrest warrant and whether to proceed with extradition requests. In this function, the IAG's role can be likened to a prosecutorial discretion and is not subject to political influence. Canada may only extradite to an extradition partner, which is defined in the Extradition Act as a state or entity with which Canada has a bilateral or applicable multilateral treaty, with which Canada has entered into a specific agreement, or whose name is listed in a schedule to the Act. Canada has 51 bilateral extradition treaty partners, and there are 34 designated partners identified in the Extradition Act. Canada is also party to several multilateral conventions containing provisions on extradition, such as the United Nations Transnational Organized Crime Convention, the United Nations Convention Against the Illicit Trafficking in Narcotic Drugs and Psychotropic Substances, and the United Nations Convention Against Corruption. There are three key stages to the extradition process in Canada. First, the issuance of the authority to proceed. The decision by the IAG exercising the delegated function of the minister to authorize the commencement of extradition proceedings before the Canadian courts. Second, the extradition hearing, which is also referred to as the judicial phase of the extradition process. And finally, the ministerial phase. This is the decision of the minister on whether to order the surrender of the person sought for extradition to the requesting state. And with that general overview, I'll hand it over to my colleague, Ms. Henchy.
So we started by mentioning there's three phases, but there's a possible preliminary phase, which is a request for a provisional arrest warrant. The Extradition Act and Canada's extradition agreements allow parties to apply for provisional arrest under urgent circumstances in order to avoid the flight of a particular person. In such circumstances, the provisional arrest, if it's approved through the issuance of an authority to arrest, precedes the other three steps. The materials submitted to Canada by the requesting state in support of a request for provisional arrest is reviewed by the IAG, International Assistance Group, acting on behalf of the minister. The IAG determines whether there's sufficient basis to proceed with this provisional arrest request, and if so, proceeds to a judge to request from a judge the issuance of a warrant. A provisional arrest warrant may be issued by a Superior Court judge if he or she is satisfied that there are grounds of urgency, the person is in Canada or on their way to Canada, and that a warrant for the person's arrest has been issued in the requesting state. Where a person has been provisionally arrested, the requesting state must submit a formal request for extradition within a specific period of time following the provisional arrest, and that period is specified in the applicable treaty. Otherwise, the person must be discharged from the extradition process. When a formal extradition request is received, it's reviewed by the IAG to determine if it meets the requirements of the Extradition Act and the treaty. In assessing whether an authority to proceed should issue, the IAG will check that the request concerns extraditable conduct within the meaning of Section 3 of the Act, and this means that the party seeking detention is an extradition partner. The person being sought for prosecution is being sought for prosecution or for the imposition of a sentence. Subject to a relevant extradition agreement, the foreign offense in which the extradition is requested is punishable by the extradition partner by imprisoning or otherwise depriving them of their liberty for a maximum term of 2 years or more. The alleged criminal conduct, had it occurred in Canada, would have constituted an offense in Canada. As a matter of practice, the IAG also examines whether the request is likely to be successful at the extradition hearing and before the minister by looking at factors that are taken into consideration at those stages, such as the sufficiency of the evidence and the country conditions in the requesting state. If the IAG does not issue the authority to proceed, if the IAG does issue the authority to proceed, this authorizes the commencement of the extradition proceedings before a Superior Court judge in the province where the person is located. The authority to proceed constitutes the authority to the judge to embark upon the hearing. The extradition hearing, which is also known as a committal hearing, takes place before a Superior Court judge who must decide whether to commit the person for extradition based on the evidence which is provided by the requesting state. Counsel for the Attorney General of Canada will file this evidence before the court at the hearing, normally in the form of something called a record of the case, which is a certified summary of the evidence available in support of extradition. This is also provided to the person sought in advance of the hearing. As Canada has an open court system, all materials filed before the courts are generally available to the public unless otherwise ordered by the court. At the hearing, the judge decides whether if the evidence were presented on behalf of the requesting state by the Attorney General of Canada would justify a committal for trial in Canada had that conduct taken place here. This is known as the double criminality test. If the judge is satisfied that the evidence meets this test, he or she will order the person committed for extradition, and the matter will move on to the ministerial phase. If the judge discharges the person from the extradition process, that concludes the proceedings. At the committal hearing, the counsel for the person sought may bring various motions, raise objections, seek additional time to prepare, all of which makes it difficult to predict how long any given extradition hearing will take to run its course. Once the extradition hearing is concluded, if there's a committal, it moves on to the ministerial phase. where the Minister of Justice must personally determine whether to order the person surrendered to the requesting state. The grounds on which the minister may order or refuse surrender derive from three sources: the Extradition Act, the relevant treaty or agreement, and the Canadian Charter of Rights and Freedoms. Counsel for the person sought for extradition may choose to make written confidential submissions to the minister to assist him in making his decision. These submissions may be in respect of any ground that might justify a refusal of surrender or may justify placing a condition on an order of surrender. The submissions made to the minister are not public unless the minister orders the person's surrender and that person then seeks a judicial review of the decision, and then it would be filed in court.
We're at the 10-minute point. I'm going to ask you to try to wrap up relatively quickly, please.
Thank you. The minister's decision balances the interests of the person sought against Canada's international obligations. He applies the mandatory and discretionary grounds of refusal in the Extradition Act. If the minister orders surrender, his decision is subject to judicial review in the Provincial Court of Appeal, and the decision of the extradition judge is also subject to appeal in the Provincial Court of Appeal. And then finally, if the committal and the surrender order are upheld by the courts, it's possible to seek leave to appeal further to the Supreme Court of Canada. And that's a basic overview of the process.
Much. Monsieur Gaudin, question de par le règlement.
Point of order. Point of order, Mr. Chair. Canada is a bilingual country, and all committee documents should be distributed in both official languages. Unfortunately, I received a document here, Extradition in Canada. Perhaps there was a mistake, but unfortunately, I do not have the French version.
I can indicate that that document is available in French. I believe we provided it in both languages.
Je vois. Oui, merci beaucoup, Monsieur Gaudin.
Thank you very much, Mr. Gaudin. In my documents, I do not see a copy in French. I must indicate to the witnesses and any other witness that would appear before this committee that if you want documents to be distributed, they must be in both official languages. And they cannot be distributed if we don't have copies in both official languages.
Yeah, it just seems to me that because I have two English copies that have been supplied on here, so I think Mr. Gaudin's, is well-founded.
So do I, and I guess that must be, I presume that's an error, but I want to, highlight again to witnesses that it's essential that we have, if you want documents distributed, they have to be in both languages. We have the deck in both languages. I realize Mr. Harris is holding up the French language deck, but we don't have, this document is only in the English as far as I can see. And I think that's perhaps an error.
Monsieur le Président, je pense que c'est une erreur.
Mr. Chair, I believe it's an error. My impression was that the documents had been tabled in both official languages. We will do a follow-up for the committee.
On va essayer ici, pour la présidence, d'assurer.
The chair will ensure that documents are not distributed until we can confirm that they're in both official languages. That's essential, so thank you, Mr. Gaudin.
Alors, Monsieur le témoin, Monsieur Rees, j'apprécie votre commentaire.
I appreciate your comment. In the circumstances, mistakes can be made. However, I want to make sure that this committee and all other committees will maintain and uphold the French language, and I will raise the flag at every opportunity in order to respect that request. Thank you. I see that Mr. Bergeron appreciates your comments. We will now continue. Mr. Chair, could I ask that all members of the committee who have English documents give them to the clerk and then start with the two others once we have them in French? It's not acceptable to have one document only in English. The clerk will obtain the documents that were distributed only in English. Thank you very much.
On est d'accord?
We all agree?
Thank you. Mr. Albus, another point of order? Or
I just would raise that there's an expectation that when witnesses comes that we try and have this, but when it's the Government of Canada, and these are obviously documents that have been well vetted or whatnot, these should be sent ahead of time to make sure this doesn't happen, because I do expect the Government of Canada to be able to meet our own standards here.
Thank you. Thank you very much. Okay. So we'll begin with the questions. Mr. Workington, 6 minutes.
Thank you, and I do appreciate you coming today. I appreciate your opening statement, and we'll have a few questions for you. Obviously, we've talked broadly about the extradition process, but the extradition process in Canada is highlighted because of one case in particular, Ms. Meng, who the majority of Canadians have heard of, and a significant number of Canadians have opinions on. I just want to clarify that in terms of her case, we are effectively at phase 2 of the process. Am I correct in that?
That's correct.
So up until now, just to clarify, the process has been undertaken without any ministerial intervention up until this point. Is that correct?
The ministerial aspect of it is delegated to officials, so officials have conducted the analysis that led to the authority to arrest and the authority to proceed.
So your testimony here today is that no government political intervention has been undertaken in the process up until this point?
Yeah, I can indicate that the authority to arrest and the authority to proceed were issued by officials without consultation directly with politicians.
John Manley, the former Liberal minister, has spoken about his opinion that a prisoner exchange should be undertaken in this case. Has your department ever advised the government in consideration of any prisoner exchange in any point in history that you know of?
I can't testify to legal advice, but I can tell you that prisoner exchanges are a matter for the Department of Public Safety.
Your department, I would assume, would be consulted with regards to the legalities of such a suggestion. I guess I would be curious, and I appreciate that the final decision would rest with them, or the request would rest with them. But my question, I guess, would be: Has your department, to your knowledge, ever been consulted with regards to a suggestion of a prisoner exchange?
I repeat, I can't discuss legal advice.
Okay. In this case, who would suggest a prisoner exchange? You say it'd be the Department of Public Safety. If a prisoner exchange was contemplated in a hypothetical case, who would initiate that discussion within government? I mean, these things don't just, they don't just materialize. Somebody would suggest it. Who would be? Where would that come from?
There is a piece of legislation related to the transfer of offenders. It applies to circumstances when people are actually convicted of offenses and serving sentences, and that offender can bring an application to have their sentence transferred to be served in another country. Prisoner exchange as a concept doesn't really exist in law.
And I don't expect you to give me legal advice in this public setting, but now I'm going to ask for it. My question is what if I was the minister contemplating a prisoner exchange in the case of somebody who was mid-process in the extradition process, so someone who had not yet been charged in Canada but was possibly going to be considered for extradition to another country. What legal advice would you give me if I was the minister asking to see if that could be contemplated?
I'm afraid
Can't give you legal advice, and I have no expertise, to be fair, in prisoner exchange.
Yeah, and as there seems to be no, I'm no lawyer and I'm no expert in terms of extradition or prisoner exchanges. There appears to me to be no portion of the process that would allow for a prisoner exchange to be considered for somebody who is mid-extradition. What would that? I guess maybe the question is what would that do to the entire framework by which extradition is built on? I mean, if we all of a sudden started to determine that we were not going to complete or fulfill our obligations under the treaties, what would that do to future extraditions, what would that do to the treaties, quite frankly?
So first of all, the Extradition Act is what we call a complete code. It has all of the information in it that is required to begin and complete an extradition process. There is no reference in the Extradition Act to prisoner exchange, so it's not a concept known to extradition law. If we chose to put an end to an extradition proceeding in a way that was not contemplated by the treaty or the Extradition Act, that would be violating our treaty obligation.
What would be the repercussion for Canada if we didn't fulfill our obligations under the treaty?
Well, I couldn't say for certain what the repercussion would be, but there would be a risk that it could bring the treaty to an end. It could vitiate the treaty.
Okay. It's strange to me that Mr. Manley would propose such an idea. I mean, he's a former minister of the Crown, and that's interesting. I appreciate your testimony.
Thank you very much, Mr. Warkentin. We have Mr. Fridges-Katos.
Thank you, Mr. Chair. Thank you to our witnesses. My colleague uses the word strange. What is strange, Mr. Chair, is that the opposition, now in referencing Mr. Manley, earlier I think they were referencing, although he wasn't mentioned, Eddie Goldenberg, the former Chief of Staff to Prime Minister Chrétien. Mr. Manley was a minister when I was in high school, Mr. Chair. Mr. Goldenberg was Chief of Staff when I was in, I think, grade 6 or 7. So let's put the facts. We're all young here. Don't worry about that. Let's stick to facts. And the facts are, I remind my colleagues across the way, that the Prime Minister has been unequivocal, and our government has been unequivocal, that a prisoner exchange is not something that is being considered or would be considered for a number of reasons. First and foremost, as Mr. Warkentin alluded to in his comments, he actually opened the door to this, it would set an awful precedent. So why would we go down that path? Now, individuals are free to write op-eds and contemplate different scenarios. It matters, if we're serious about policy, it matters what the Prime Minister has said, it matters what the government has said, and the government has been very unequivocal in all of this. So I think it's important to recognize that. To the witnesses, if I could, interested in the technical issues surrounding extradition, and if you could go through, for us non-lawyers on the committee, if you could go through a few things with me, just so I can understand them better. What types of information are typically sought in mutual legal assistance requests? I know you opened the discussion on that, but what sort of information are we talking about?
So mutual legal assistance is to assist prosecutors in different countries to access evidence for criminal prosecutions. So there's a wide variety of things that could be sought. That would be of assistance in pursuing a prosecution. So it could be witness testimony, it could be documentary information. A lot of the time it involves internet service provider information, so telephone records, texting records, email records. It's increasingly important in criminal prosecutions. It may be the access to a particular item, a murder weapon, for example, could be transferred across the border pursuant to a mutual legal assistance request. Those are the general types of things. It could be anything, basically, that is relevant as a piece of evidence in a prosecution.
Okay, I'm looking at the slide deck, and maybe the answer is obvious, but I still think it's interesting. On page, I guess, 10. There's a wide gap year over year between the number of requests received and the number of requests made. Is there any information you could pass along as to why that gap is just a matter of how the treaties work out? And
I think it's just a question of population. So Canada is big geographically, but relatively small in population. We have treaties with countries all around the world. If you add up all the crimes that are being committed around the world versus the crimes being committed in Canada, there's going to be more requests coming to us than requests that we'll be making.
Sure. No, I thought so, but good to get that on the record. Obviously, you cannot comment on the case of Miss Wanzhou. I understand that, but Canadians are still following this issue along and do have questions. The issue of double criminality, that requirement has come up. Can you tell the committee what the purpose of this requirement is in our law and cases where the courts have said it is not satisfied?
The purpose of double criminality is the basic principle underlying extradition, that a country does not want to send somebody from their territory to another territory to be prosecuted for something that they don't consider to be criminal. So if a country has an offense that we would not recognize as criminal law, we wouldn't extradite somebody for it, and vice versa. This is applicable all around the world. All countries apply this principle of double criminality to extradition. So it doesn't matter if you have exactly the same offense, but it's the conduct that we look at. So if what the person did would be considered criminal in your country, then that will satisfy double criminality and will allow for the possibility of extradition.
Okay, with 1 minute left, could you tell us cases where the courts have said this has not been satisfied?
I don't have any examples directly in mind. It happens very rarely, just simply because we assess the evidence before we bring it before the court. And we don't bring cases before the court if we think there's insufficient evidence for the judge to find double criminality. So occasionally there might be a gap in the evidence. It doesn't quite meet the test for a particular offense, but as I said, it doesn't happen frequently.
20 seconds. Can I just ask, in the course of a decade, how many people does Canada seek to extradite from other countries? And then we'll go.
That's a good question. I'm not sure I can answer. Just a second.
Well, perhaps you can get back to us on that. And Mr. Elvis is asking if you have it, the breakdown of countries we've requested extradition from also. If that's possible to give that to the clerk later on. Okay. Thank you. Monsieur Bergeron.
Oui, Monsieur le Président.
Yes, Mr. Chair. This notion of reciprocity is interesting in terms of crimes in a foreign country, to see what the possible equivalent would be in the Canadian legal system. Of course, this applies to extradition cases, but also to cases of providing visas or documents authorizing travel for Europeans, for example. For instance, we had Puigdemont from Catalonia, to whom we refused entry to Canada because he was apparently accused of a crime which, frankly, on the world stage is a little obsolete, the crime of sedition. It would seem that we had to stretch to find an equivalent in the Canadian Criminal Code. But let's get back to the case that interests us. I understand that the first step is that the International Assistance Group is charged with determining if a provisional arrest warrant will be issued. In the assessment that this group performs, are there any questions raised about this equivalency in Canadian law? Or do we just receive the request from a country that's requesting extradition? We see that it's justified and we just proceed?
So I can advise that when we receive a provisional arrest request, we look at, they provide us with a summary of the evidence. So we don't get the actual evidence at that stage, just a summary. And we assess whether or not, in our view, it would meet the criteria for double criminality. And if it doesn't, then we wouldn't proceed to seek a warrant for provisional arrest.
OK. Donc, on...
Okay, so we take a look at it, if I understand you correctly.
We assess it before.
Okay.
The first step is we have to assess it and be satisfied that we think that, first of all, it's possible that this evidence is going to justify the issuance of an authority to proceed down the road. and whether it meets the criteria for urgency that would allow a judge to issue a provisional arrest warrant. So we review it, and in some cases we refuse to seek the warrant.
Donc, le service dans
So the International Assistance Group looked at what Ms. Meng Wanzhou was accused of, and that it contravened American sanctions against Iran, sanctions which Canada does not even apply. My question is, under the circumstances, on what basis did we decide to accept this request from the United States?
Discuss a specific case.
But we can tell you that there was an authority to proceed issued, because that's public record, and the authority to proceed identifies an offense that we believe was made out on the evidence that's provided by the foreign state, and the authority to proceed in the Meng case identifies the offense of fraud.
OK. Donc, si je comprends bien,
If I understand correctly, in the criminal charges that are sent to us by the country in question that is sending us this request, we look at the charges that could eventually apply to the Canadian Criminal Code.
OK. Donc, si...
Okay. And if there are charges that don't apply, and some that do apply, we will proceed?
Satisfied that there is a Canadian offense that could be made out on the facts. So we don't have to match all of our offenses with the foreign offense. We look at the conduct and we ask, is there a Canadian offense that arises from that conduct? And if so, we identify it and put it in the authority to proceed.
Je vais revenir sur la question, Monsieur le Président, si le temps me le permet.
If I have time, Mr. Chair, I'd like to come back to the issue of the proposal of a prisoner exchange. I would like to remind my colleague, Mr. Fragistakos, that when talking about the opposition, I would have preferred him to specify the official opposition, because neither my colleague from the ADP nor I were associated with what was said. However, it remains that there is a relevant question in the sense that this idea, personally, seems to me completely unacceptable for at least 3 reasons. The first is that exchanging 2 for 1. It seems to me that that's completely unacceptable. Second, Canada has insisted from the very beginning that this is a process that falls under the rule of law. Now that we're in the second step, which is the legal system step, how could we get around the legal process in a country subject to the rule of law to establish a political agreement between 2 countries? That's my second concern. And also, it must be recognized that such an agreement between China and Canada would constitute an invitation to all authoritarian regimes throughout the world to imprison Canadians and eventually proceed with a prisoner exchange. This idea, which I know could have been furtively reviewed by the government, although the government did categorically reject it since, I recognize that. This idea seems completely unreasonable to me. Is my analysis sensible to you?
I can't really comment on that, but as I indicated earlier, the Extradition Act does not contemplate prisoner exchange.
Merci beaucoup, Monsieur Bergeron. Mr. Harris.
And I have a series of technical questions that I think you've talked about 3 different phases, but as I see it, there are 5 processes going on. The decision whether to arrest somebody provisionally, the decision whether to issue an authority to proceed, the extradition hearing itself, which decides whether or not there's sufficient evidence to stand trial if it was an offence in Canada, and I call it the preliminary inquiry standard. The next phase is the decision by the Minister of Justice whether to surrender the individual. And an overriding process, which I call number 5, is the act that allows the minister to withdraw the authority to proceed at any time. And stipulates that if the minister does so, the court shall discharge the person and set aside any other order made under either judicial interim release or the detention. So these 5 processes, I take it that number 1, decision whether to issue a warrant for arrest, is under the advice of your IAG group, the internal group. Not the minister. There's no political involvement or even possible. The second one, the decision to issue a authority to proceed, you're saying is delegated by the Minister of Justice to departmental authorities. Is it true that the minister would have no opportunity to intervene or say anything about that? Is that I understand that the officials carry out this assessment and make a determination. But is there no role for the minister even possible?
First, if I can just go back to your first comment about the arrest, that is a decision made by the court. So we bring an application to the court for a warrant.
Fair enough, yeah. But the decision to ask for the warrant is made internally, is not?
That's right.
So the minister doesn't decide who to arrest and who not to arrest, or warrants should be sought for.
That's right. But the arrest can happen in one of 2 ways. So
no, I understand. So let's say we have someone arrested, and then between the arrest and whether or not something proceeds, there's this authority to proceed question.
That's what I'm trying to explain, is that the authority to proceed sometimes precedes the arrest.
I understand that too. But if that hasn't happened, if you have the provisional arrest, which we did in this particular case of Ms. Meng, there was a decision after she was arrested to whether to seek an authority to proceed or whether the authority to proceed would be issued. There was a period of time, I think some 10 or 12 days or maybe more, during which time we did hear from President Trump about some comments that he made, and between the time of the arrest and the time of the issuance of the authority to proceed, there was a period of time where the authority to proceed was issued. You're saying that authority is delegated, but my question is that delegated in the sense that the minister cannot have any say in it whatsoever?
So as a matter of practice, everything has been delegated in the Extradition Act. All the ministers' discretion has been delegated to officials with the exception of the decision to order surrender. And the reason for that is in order to insulate the minister for that very important decision that he has to make at the end of the process, and to ensure that he doesn't prejudge the outcome of that important decision. So for that reason, the minister is not involved in the issuance of the authority to proceed, has never been involved in the issuance of the authority to proceed.
So that's a consistent practice.
It's a consistent practice.
Okay, that's
yes.
important to know. I think we need to establish that. So after the first involvement of the Minister of Justice, and we're talking about the Minister of Justice here, not the Attorney General. They're two different hats, but the same person. But we're talking about the Minister of Justice role. After the extradition hearing, which takes place, if there's a decision made that there's sufficient evidence to convict, if properly instructed court, etc., within Canada, after that, the Minister of Justice has a decision to make as to whether to surrender the individual. That's a ministerial decision. And then what I call the overriding involvement or potential involvement is the act allowing the minister to withdraw the whole case. So these are both, at the end, decisions that are made by the Minister of Justice, those last two. Am I correct?
No. So you're correct about how you characterize the minister's decision. So after the committal, if there's a committal at the extradition hearing, it goes to the minister. The minister makes the decision about whether to order surrender, and it's the surrender order that will empower the person to be transferred to the foreign country who's making the request. The withdrawal of the ATP is only relevant before the decision of the extradition judge. So once the extradition judge has ordered surrender, the ATP is used. It's been decided upon. So the withdrawal of the ATP is also delegated to officials, and it's the existence of this power is there for circumstances where something changes between the time that the authority to proceed is issued and the time that the extradition judge makes a decision on whether to order committal. So, for example, if the extradition partner withdrew their request after the proceedings had commenced, we can withdraw the authority to proceed in recognition that there's no longer a basis. or something happens to the evidence that we had reviewed in order to issue the authority to proceed, and we no longer had confidence that there was sufficient evidence to justify a committal, we can withdraw the authority to proceed.
Okay,
so that action is taken by officials. In my department, in the International Assistance Group, it's not taken by the minister.
Can I ask a specific question?
Mr. Harris, I'm sorry, but your time is up. I'm sorry. I hope we'll get back to you because I want to.
Question,
well, absolutely. And in fact, I wouldn't. I'm almost tempted. I wouldn't dare, but I'm almost tempted to comment favorably on having another lawyer on the committee. But I better not do that.
Sure, you saw that.
Thank you, Monsieur. Mr. Albus. 5 minutes.
I would just ask, Mr. Chair, if I could give a minute of time just so I could hear Mr. Harris's, because I was actually going to go into this line of questioning.
Terrific. Mr. Harris, thank you very much, Mr. Albus. The question was simple. You're suggesting that the overriding power of the minister, which says at any time, is actually spent once the hearing is complete, and that the question then is, has that power, to your knowledge, ever been used?
Yes. Yes to the first part of your questions. It's spent by the time once there's a committal, you can't withdraw the authority to proceed. But the minister still has the power to end the proceedings by discharging at his stage. So the withdrawal of the authority to proceed is handled by officials, and that's prior to the committal decision. And then once there's been a committal decision, the minister is making a decision on surrender. His decision could be to surrender or to discharge, and a discharge would bring the proceedings to a close.
Has it ever been used?
So, yes, the minister is discharged, and yes, officials have withdrawn an authority to proceed in circumstances, as I've described, where the evidence is no longer available or where the case has been withdrawn by the requesting state.
Mr. Harris encroached a tiny bit on but I think Mr. Albus is okay with that. Mr. Albus,
okay with that. Thank you very much for your presence here today. Just in regards to that, could you supply the committee with the last time that kind of discharge process happened, just so we can see if whether or not this has been used recently or if it's something that is only been happened rarely in our history. I'd like to ask a little question about the Minister of Justice component. Obviously, we're talking about the Minister of Justice, not the Attorney General, and therefore Shawcross doesn't apply in this case. Is that correct?
I'm not sure how to answer that question. We wouldn't be in a position to provide you with legal advice on the application of the Shawcross principles.
Well, I
think I'll leave it at that.
Well, the treaty, though, specifically, and this process says the Minister of Justice in his or her capacity, not as Attorney General, or else it would say Attorney General. So can the Minister of Justice, in addition to receiving the decision of the court, when it moves to the ministerial phase, can the Minister of Justice, in his or her capacity, receive, be lobbied by other members of Cabinet?
I can't speak to whether Cabinet can lobby, but what I can tell you is that there are very limited matters that the minister should be considering in making his decision, and those are issues relevant to the extradition process. So, the treaty, the Extradition Act, and the Charter of Rights. So, extraneous issues that are relevant to the government in other contexts would not be relevant to the decision on an extradition case.
Okay. Well, just again to that, though, is it a cabinet order? Can the minister take the decision of the court to cabinet to solicit feedback in a formal mechanism, or must the Minister of Justice, through another mechanism like the Canadian Gazette or through some other way, make that decision independent of cabinet?
Decision is made independent of cabinet, and it's pursuant to the Extradition Act. The minister issues an order of either discharge or surrender. It doesn't go through the Gazette, and it doesn't go through cabinet. Okay, so
I only have a moment here. So media reports say that the Chinese government first found out about Ms. Meng's arrest from Huawei rather than from the Canadian government. Can you comment on that?
No, I think that'd be a question for Global Affairs.
That'd be a question for who?
Global Affairs.
For Global Affairs, and we just had them. Okay. Thank you, Mr. Chair.
I think we'll have them again, of course.
Yeah,
or
I think
some people from both.
you know what, Mr. Chair? I think that's a great idea.
Well, thank you, but I mean, we'll have some people, whether it's those or others, but we'll figure that out, I'm sure.
I'm just glad to see we have some multi-party support for that.
Mr. Dubourg. Oh, excuse me, Mr. Elephant.
Thank you. And I'm going to actually pull on what Mr. Harris and Mr. Albus were questioning, because I'm not a lawyer, so it takes me a little bit longer on this issue. I'm understanding the ministerial decision on surrender and the basis on which that would be made under the Act, under the particular bilateral treaty, and under the charter issues after a Superior Court has rendered its decision, and that's one process. On the ability of the minister after the decision to authority to proceed, between that and the ultimate court decision, it sounds like if circumstances change or if new evidence is presented or an extradition request is withdrawn, that is then allows the minister to stop the proceedings. And I just want to make sure that I understand two things. What criteria are involved, what precedents are involved, and where the burden lies on understanding how that decision would be made. Like, who makes that case and how does it happen?
So the ability to withdraw the authority to proceed is provided for in the legislation, and it has been delegated to officials in the International Assistance Group. The considerations are the same considerations that would exist in issuing the authority to proceed in the first instance. So we consider whether there's sufficient evidence, whether it meets the requirements of the particular treaty, and before we would issue an authority to proceed. So if the considerations that were taken into account in issuing the authority to proceed change and no longer exist the way that they did at the time the authority to proceed was issued, that would be the basis for withdrawing the authority to proceed.
And is that a delegated decision as well, or is there a nuance of difference or a difference between the delegation on the authority to proceed and the subsequent authority to not proceed?
No, they're both delegated to
They're
officials.
both delegated.
Yeah.
Okay, that's the part that has been kind of getting. And that delegation, is that by convention? Is that the understanding our treaty partners have, or where does that lie?
So it's not an issue for treaty partners. It's an internal justice issue, and that was determined when the legislation first passed. A decision was made that all of the discretion that was vested in the minister would be delegated to officials, with the exception of the decision on surrender, in order, as I said earlier, to insulate the minister so that he can be as independent as he possibly can be at that stage of the proceeding.
Understand. And then after the final decision, I would add a sixth thing to Mr. Harris, and that's the potential appeal of the decision to the Supreme Court. So it could go even 6 stages. Am I correct on that?
So there's 2 levels of appeal. There's an appeal as of right to the Court of Appeal of the province. So it could be the British Columbia Court of Appeal, the Ontario Court of Appeal, depending on where the case is. And that's an appeal from the committal. And there's also a judicial review of the minister's decision. Those 2 things are heard together if they're both brought, and again before the Court of Appeal. If the Court of Appeal upholds the decision, their leave can be sought from the Supreme Court of Canada for a final appeal. Leave is rarely granted. It's only granted in cases of national importance.
And maybe my last question, and I think I know the answer to this, does the requesting country have any standing in any part of any of those 6 or 7 processes? Do they have any rights in terms of making presentations?
No, the requesting country does not appear in court in extradition cases. So
Anywhere.
No.
So their only time is under the treaty, they request an extradition, and then it is up to our processes. So following Canadian jurisprudence, following Canadian rule of law, following all of those things.
that's correct.
Okay. We have 18 seconds.
Well, Mr. Oliphant, okay. No, we have a minute. We have a minute.
No,
If
it's
it's-
5 minutes. It's a 5
Oh, sorry, I'm mistaken. There
Very
isn't a
good
minute.
at keeping my-
Well done. Thank you for assisting the
I
chair. in
suggest that to
and
all members.
Helping to keep me somewhat out of trouble. Mr. Jenis.
Well, thank you, Mr. Chair. And there's one issue that hasn't been discussed yet that I want to drill into a little bit. In 2016, the Prime Minister had posted a joint statement suggesting that Canada had agreed to negotiate an extradition deal with China. That was partially walked back, and there was some confusion, I think, in the discussion about whether the government at the time intended to or did not intend to negotiate an extradition agreement with China. Could you just share with the committee, was there a plan at the time? What was the context of the Prime Minister saying that they were considering negotiating an extradition agreement with China?
So, of course, I can't speak on behalf of what the Prime Minister meant, but I can tell you that there was an agreement with officials that we would consider the possibility of an extradition treaty. So it was something less than agreeing to negotiating a treaty. So there was discussions that were undertaken to consider whether we would negotiate a treaty.
Okay, and this is maybe where there was discussions to consider. Did those discussions to consider involve discussions between Canadian officials and Chinese officials to start to map out what that agreement could or would look like?
There were discussions between Canadian and Chinese officials about the Chinese interest in negotiating a treaty.
Okay. So they were interested in a treaty, and there were discussions between Canadian and Chinese officials about it. And the Prime Minister said, according to the statement, yes, we would be willing to negotiate this treaty. And then meetings took place, I can assume, after that between Canadian and Chinese officials. What happened next in terms of those discussions?
So again, I can't speak to what the Prime Minister said or didn't say. I can tell you that there was an agreement between officials that there would be discussions, and discussions took place. Where that fits into what you're describing as a statement from the Prime Minister, I can't tell you.
Okay. So after that agreement, there were discussions between officials about this. Not just before, there weren't just discussions about having that statement, but there were discussions after the statement about next steps. Is that what I'm understanding you to say?
There were preliminary discussions about whether we might be interested in negotiating a treaty. No treaty's been negotiated.
Right. Are those discussions still going on?
They were not formal discussions, so they didn't formally commence or formally end. It would be possible to continue to have the discussions.
It would be possible to continue to have the discussion. So you haven't at any point gotten policy direction from the government to cease to have those discussions?
This wasn't a policy direction from the government. It was an agreement between officials.
Okay.
To have a discussion. There was no formal mandate from the government to negotiate a treaty.
Well, but the Prime Minister said publicly that this was happening. So, of course, you can't answer for what he said or didn't say, but presumably officials note when the Prime Minister makes a statement like that, and it shapes what actions are then taken. So, is it your understanding that the rules of engagement vis-a-vis that extradition agreement as they existed in 2016 that they continue to apply, or has there been subsequent statements contradicting that or changing that direction from the political level?
There's never been any formal mandate to negotiate a treaty with China. That hasn't changed.
Okay, but an informal mandate to have conversations. I mean, I'm just trying to understand this so that people watching at home can get a sense of, because the Prime Minister did say there was a joint statement. And clearly, when there's that joint statement saying, we're prepared to move forward with this, that influences what next steps are taken or not taken by officials.
And why? I don't have anything more to say other than that we don't require a formal mandate to have discussions, preliminary discussions about whether a country might be interested in a treaty. These kinds of discussions happen amongst officials between Canada and a number of different countries there.
Okay,
but to negotiate a treaty, we would require a formal mandate, and we don't have one.
So when was the last time informal conversations happened between Canadian officials and Chinese officials on an extradition, on the possibility of an extradition agreement between the two countries?
I'm sorry, I don't have that answer.
Okay, could you come back to the committee with an answer in writing? Is that part of the?
I'm not sure if I can even get you an answer because the discussions could have taken place between officials from my department, but they could have taken place from officials in global affairs. I'm not sure I can
perhaps
give you.
You can check on. Is it? I'm going to ask you if you can to do so. Mr. Albus, you have a point of order, perhaps, because we are at the end of the time.
I do realize that, Mr. Chair. It's just you had asked earlier for extradition by countries and how many get done. If it's possible for the department to also include how many extradition agreements are with countries that have the death penalty of those lists, I think it would be reasonable.
Mr. Chair, point of order?
Yeah, Mr. Prajkalis.
I do have a point of order, Mr. Chair, just to add to the comments or the questions put forward by Mr. Jennis. Perhaps
Is it a
would
point
add
of
to
order or
our
debate?
understanding that according to a 2016 National Post article, it just adds to the discussion, Mr. Chair.
This is not a point of order. It sounds like it's debate, and I think we may have occasions to debate, of course, in the future, but I don't think it's a valid point of order. J'aimerais noter que les membres du comité
I would like to note that the members of the committee now have copies of the documents which were originally circulated only in one language, and I believe that this document, extradition in Canada, has been distributed by the clerk. However, I must indicate once again to future witnesses that if you want documents to be distributed, it must be done in both official languages of Canada. Thank you, Mr. Chair.
This is very much for appearing today, and remind colleagues that we're meeting tomorrow night from 5:30 to 7:30 p.m. with Ambassador Barton, but I especially want to bring to members' attention, just a reminder, that we're meeting tomorrow night in room 415 Wellington, so in the Wellington building, because, of course, we might otherwise come here by mistake, where we've been meeting regularly. Okay, 415 Wellington. Thank you very much. The meeting is adjourned.